I was a trial judge for years, so I now want to examine how some of Judge Scherer's recent rulings might affect the outcome of this case.
This whole situation here has become unprofessional, to say the least. There should be, when I say court is back in session, every lawyer should be in their seats and paying attention. The fact that I have to ask multiple times whether one particular side is ready and no one's hearing me because you all are talking to each other is rude. It's rude and it's unacceptable. There needs to be, everybody needs to be in their seat. Everybody needs to be quiet. You all have computers. You can be instant messaging one another or passing notes and occasionally talking, or if you need to talk to your client. But there's constant talking, there's constant movement, there's printing, there's getting up and down. It's got to stop. This is a courtroom. It needs to run like a courtroom. It's become somewhat of a playground, okay?
Following that reprimand, Judge Scherer got tougher on the courtroom rules. The attorneys, for instance, now have to ask permission to do anything, whether it's go to the bathroom, remove items from a briefcase, get up from their chairs. Now they have to ask the judge permission. Still with me, Nima Rahmani. Nima, I want to talk about this a little bit because the fact of the matter is, and I'm saying this as a former judge, the one who manages the courtroom and how everyone behaves is the judge. And so I too, watching some of the attorneys' behaviors, felt that it was unprofessional, a little bit rude, because there was so much movement in the courtroom. Some of it's necessary to try the case, but a lot of it isn't necessary. It's just a little loosey-goosey from my perspective. So I get that she finally said something and said, no, we're not doing this anymore. But the way in which she handled it, what was your take on that?
Yeah, sometimes judges, they get frustrated. And ultimately, Judge Ashley, you're right. It's the judge's responsibility to control his or her courtroom. And there's some judges that come out the gate and they are strict. They don't allow anything. And others are nicer until you push them over the edge. And that's what may have happened here. But ultimately, for Judge Scherer, you got to be careful because you know this case is going to be appealed if Nicholas Cruz receives a death sentence. So those mandatory state and federal appeals. So everything you do needs to account for those appellate judges carefully reviewing the record to make sure nothing improper was done.
Absolutely, and I'm just going to take that one step further and suggest, what if an attorney needs to get something off a printer or circumstances are such that they don't get a long enough break and so they have to stand up to go get a piece of evidence that might be on opposing counsel's desk. We know this is, you and I know, that's the reality of trying a case.
Sure.
That happens sometimes. And so I do wonder if such strict rules, if she enforces them, and that's an if she enforces them and says, you don't get out of your chair, Nima Rahmani, until you've asked my permission. If she truly enforces that, does that hamper potentially the defense's ability to represent their client, in your opinion?
It does, and I can tell you in 20 years, I've never had to ask for permission to get something out of my briefcase or to stand up. I mean, in fact, you're supposed to stand up when you address the court and when you address witnesses. And, you know, God forbid I have to use the restroom and the judge doesn't allow me to do so. Well, guess what? That's going to be a problem, not just on appeal, but with, you know, whatever judicial board in Florida is going to be evaluating that particular judge. So, you know, I understand it's her first death penalty case, and it's probably one of the most high-profile capital cases in U.S. history. But you got to maintain composure if you're going to be a judge.
And I agree with you. You can have a lot of frustration as a judge when all these things are going on. It's how you handle it. I would love to hear from you, viewers. Do you think that it was a proper way to control the courtroom and say, we're not going to have any more of this chaos, my word, not hers, but chaos in the courtroom? Or did you feel that Judge Scherer crossed the line and instead rather went on a rant that may or may not have been appropriate? Let us know. You can certainly tweet us or send us social media so we can see what you think about that. Now let's look at some of Judge Scherer's rulings on recent motions that really may affect the trial in terms of the evidence. So first, let's talk about this one, Nima. The judge, Her Honor, allowed the jury to see Nicholas Cruz's drawings of swastikas last week. This after not allowing part of a video deposition from a friend of Linda Cruz who said that Nicholas was obsessed with swastikas. So two rulings, really. Yes, they could see this, but they can't hear any testimony about obsession. There's some hearsay, objections, rules in there. But what do you make of how that might affect the defense doing their job?
I think those are appropriate rulings because what Cruz is wearing on his boots or his weapon, I mean, to the extent that the state can prove that that's something that he did, that's properly evidenced. That those are aggravating factors. If he did it for racially motivated reasons, that's something that the state can introduce into evidence. Now, a neighbor's deposition testimony that may be hearsay or lack foundation, again, that's properly excluded unless the state can prove that actual knowledge and that witness is testifying about something that he or she personally observed. So I think those were correct rulings in this case, Ashley.
Right, and Nima, you know, part of what I also look at in a case like this is, does the judge, when the judge makes a ruling, do they put on the record very clearly the grounds for the ruling? Because an appellate record requires that. I have to say, if I'm on the bench, that a motion, that an objection is either a sustained, overruled, and the grounds for it. And so I think that that makes a significant difference. And I have noticed that Judge Scherer does tend to put on the record the grounds, the reason why she says, as you so well articulated, that she has made a decision one way or another. But here's another decision that she made. She denied testimony from a witness who alleged that the defendant was sodomized by a neighborhood boy at the age of 10. Now, the reason that she said she was not going to allow this is because the state did not have anyone to rebut the testimony. Let's listen to that together.
What concerned you about the fact that Zachary and Nicholas were living with Roxanne DeChamps?
When I was living in New Jersey, I reached out to Linda, and Linda told me that Roxanne DeChamps' son sodomized Nicholas.
And what was his name?
Judge, Your Honor.
All right, Nima, so again, we have some hearsay issues. This witness is saying that Linda, who is Nicholas Cruz's mother, who is deceased, did say that he had been sodomized by a neighborhood boy. But it's interesting, the judge's reasoning is what I want to talk to you about, because again, the judge said that's because the state had no one to rebut the testimony. Well, I mean, during the course of the case and the defense's mitigating case that they're putting on, arguably the state could try to find a witness to rebut it. So is this a decision you're in agreement with the judge making at that point in time and saying, no, it doesn't come in?
Judge Ashley, I agree with the judge, but not for the reasons that she articulated. The rebuttal doesn't make sense. If you're the state, you can't prove a negative. Logically, that doesn't flow, that an event didn't happen. But obviously, you have a statement from an unavailable witness, and there are certain statements, hearsay statements, that come in if a witness is dead or not subject to subpoena or just out of the jurisdiction. But none of those hearsay objections apply. So I think that would have been a proper basis to exclude the evidence and not the reason that the judge articulated.
Right, I agree. I think that the reasoning is what really concerns me in that particular ruling. Finally, we are waiting on Judge Scherer's ruling on alleged witness tampering from the prosecution. Now, this is a huge motion. The defense has asked for a mistrial. That's not an insignificant thing to do. And alleging prosecution witness tampering is not something that is taken lightly. And so the arguments have been made to the judge. Judge Scherer has to make a decision. And here's what I would suggest is that, number one, she has to give a very clear evidentiary reasoning behind her finding. And number two, she has got to be clear that it is appearing to be non-biased. What do I mean by that? If you look at her record of all the rulings that have been made, some have pointed out that many of them are pro-prosecution. That's okay, as long as it's for the right legal grounds. So that's what I'm going to be looking for, the right legal grounds there and the decision that she makes. You're not going to want to miss. We'll, of course, let you know when that ruling comes out.